the notes are in your file that we have come before you before previously requesting relief on the bond. And so we are back again, obviously, because my client still cannot post a bond. I do want to re-summarize the facts of this particular case. And I know that Ms. Ortega has had an opportunity to review it. I think the last time we were here at the bond hearing, I don't think the prosecutor was super aware of the facts of the case other than it was a shooting, which at first glance seems necessarily awful. But I want to make sure that I re-summarize the facts of the case, and Ms. Ortega can correct me if at any point she believes that my summary is incorrect. I think it's important for the court to understand exactly how this played out and how this occurred. My client was in high school when this happened. He was a senior getting ready to graduate. I believe this happened like a week or two before high school graduation. He was with fellow high school students of a male friend of his. The male friend of his was fighting with an on and off girlfriend. And eventually, I guess with technology today, she shared her location and they figured out that she was at El Cometa. So my client, who has no beef in this at all, goes with his friend, and his friend goes inside of El Cometa to confront the girl who's also in high school. This is all high school drama. So the friend grabs the cell phone that belongs to the girl, runs inside of the men's bathroom and locks the door. And this is what's happening inside of El Cometa. In the meantime, my client is outside in the parking lot. Apparently, while this is occurring, there is an individual who is not the person that is initially, or the person that is ultimately shot. There is an individual inside of El Cometa who apparently is trying to instigate or starting beef with my client that is outside. In fact, in a statement that was taken by the second complaining witness that was shot, that was the off-duty Border Patrol, his girlfriend tells law enforcement that it was the individual inside of El Cometa that was the instigator. That is in her statement, saying that she believes that the guy inside, she could hear him saying, "You want some of this? You want some of this?" And then the guy ultimately went outside to pick a fight with my client. It is a direct quote in her statement that that first individual male escalated the whole thing. That is a direct verbatim quote in her statement. Eventually, that person goes back inside after punching my client in the parking lot. He goes back inside and my client is still outside. Then the second victim in this particular case, who was an off-duty patrol officer at El Cometa at 1 something in the morning. I don't know what the sobriety level was. It could have been totally sober or it may not, but this person decided that he was going to go save the day. It was noble enough in theory, and he was going to surprise my client from behind and try to take the gun that my client had from behind him. So all of the witness statements are 100% consistent that this second victim comes from behind, surprise attacks my client. My client has no idea who this person is, other than there was one individual that already came outside and punched him. And so my client at that point shoots the second person, who turns out to be the off-duty Border Patrol agent who was trying to, I suppose, handle the situation. Again, it was noble in theory. I don't know that it was the smartest thing to do. He got shot. He is fine. I believe that there is no long-term anything. And now my client is here standing charged with 2 counts of ag assault. I want to make sure that the court understands the fact pattern, that this wasn't my client has a gun, looks across the parking lot, takes his gun, cocks it, aims it, shoots it. That's not exactly what's happening here. He is being caught by surprise from being assaulted from behind. That is the fact pattern of this particular case.
Ms. Butterworth, while he's holding a weapon, so allegedly.
Yes.
So
Yes.
alleged high school drama, and your client is the only one that decides to allegedly take out a firearm.
That is correct, Judge. And I've spoken to my client. I've spoken to my parents, my client's parents. I understand that is the problem here, and everyone's aware of it. However, we're at a bond hearing at this point. How the case ultimately gets resolved, we're gonna figure it out. There are common denominators here. My client is a dumb high school kid. That is a huge problem in this fact pattern. But he's a high school kid, and so he lives at home. He would continue to live at home with his parents. Nothing like this has ever happened in his life before, and we're gonna try to resolve the case. I don't know how it's gonna get resolved. He's probation eligible from a jury, but right now we're here at a bond hearing where he has no prior criminal history. He comes before you as a kid, and his parents are here to try to assure the court that he would absolutely come to every single hearing that is set as we continue to try to go forward to resolve it, and that they would monitor him, that they would make sure that nothing like this happens again while he's out on bond. And he understands the magnitude and the severity of the charges and what he's looking at. He had never, ever been in trouble before. And so here we are, we have this high school kid. I don't like to, I'm not going to beat around the bush. He had the gun. That is a problem. But I do think that he is a candidate that should be considered for a bond, being that he's a high school kid that can live at home with his parents who can monitor him.
Anything else?
That is all. Thank you, Judge.
I just want to make sure, I believe I denied it before, but was he at 100? Let me go back. What is his bond right now?
I'm going to need the court to 100% tell me, because he's got 2 counts. He's indicted on 2 counts under the one cause number, but he was arrested on 2 separate occasions and given 2 separate bonds.
Right. So I see a total of 185. The initial warrant was 150, and I'm seeing now this is split. Ms. Welch, can you tell me a little bit about what his bond is? Just tell me what the bond is exactly.
Yes, Judge, I'm pulling up the order right now. So it is 50,000 corporate surety, but with all the counts makes it 135,000, and then 50,000 PR for the split bond. This is when it was indicted back in June 24th of 2023.
Okay, so yeah, so they initially put 50,000, they added, so if he's still at the original, I was looking at the warrant and it said 150,000. So the initial warrant was 150. And then I guess they went before the jail magistrate and went up to 235. And now he's at 185 split, 135 cash surety, 50,000 PR. All right, Ms. Ortega?
Yes, Your Honor. So our facts do not, obviously Ms. Butterworth was stating the truth about the facts. It's the state's position today, though, that this did go beyond the high school drama. He did have a weapon. But more importantly, Your Honor, I wanted to draw attention to additional facts that Ms. Butterworth did not mention in regards to the surveillance video, because we think it points out a danger that this individual is to the community, in that, again, this did occur at El Cometa, but I have notes from the surveillance video at 2:45 hours, the offender is seen looking inside the restaurant and making hand gestures while holding something in his right hand by his waist. And then we're able to see them exiting and he's showing off the gun while looking inside. And so, but, this is, again, a place that does get, crowded during those hours. It's just the hours that the business operates. So we do believe that this individual is a danger to our community. The state is recommending 7 TDC for this defendant on these cases, and we would respectfully ask the court to find that the bond is set appropriately. Thank you.
Ms. Butterworth?
Judge, I have not been able to have access to these surveillance videos. I have turned over my age is gonna show a disc, whatever the formal term is for these surveillance videos to be copied onto them, and I still haven't received them. But I'm also not denying that my client is acting a fool in the parking lot with his gun. I'm not denying that happened. To treat it though as almost a homicide or a manslaughter, he's a high school kid and we're here for bond purposes. I understand very well the arguments that Ms. Ortega is making. And ultimately it may be a case that has to go to a jury since he is probation eligible. I believe right now that the TDC rec is, to me, more appropriate for somebody who's maybe had been in trouble before, but this kid has never, ever been in trouble before. I get that the circumstances are foolish and dumb and dangerous and stupid, and I could come up with all sorts of more adjectives, but at the end of the day, he's got two parents that are going to watch over him while he's out on bond. And that's what we're here for. I know we're arguing ultimate jury type style arguments, but it's a bond hearing where I'm asking for consideration. They cannot post this bond right now. It's too high. He's technically considered innocent until proven guilty. He is probation eligible and he was in high school. I can't stress that enough. He was in high school. And so because he's never been in trouble before, and I do think that that should be heavily considered. This isn't a kid that was in trouble back to back to back to back. This is his first anything. It was incredibly stupid. 7 TDC stupid? I don't think so. I don't know about that, but we're at a bond hearing right now. And so that's what we're arguing. And again, I have his mom and his dad here. He's got a great family. This isn't a case where you have to be concerned that he's going to go home and the dad is a gang member and the mom is on drugs. This is a very good family who is going to help supervise him. And they'll have everything to lose. They're the ones that ultimately, if the bond can get low enough, will post their money to do it.
And Your Honor, if I may reply to just one thing, I will just add in regards to the danger to the community argument that there were people inside the restaurant in the video that are seen moving away from the window and taking cover. And so
unfortunately, Ms. Butterworth, my concerns are the same from the last bond hearing. I recall the last bond hearing. Believe me, if it was Mr. and Mrs. Bettis that I was putting on some kind of bond conditions, I'd be perfectly fine with that. The nature and the circumstances of the offense and the future safety of the community are very much more outweighed than any other consideration on the bond. This is the allegations. I completely understand. Client is presumed innocent, but the allegations as such, I think, warrant the bond that he has. So your request is respectfully denied.
Thank you, Your Honor, for your consideration.
Thank you for your time. Who's next?
May we be excused?
You may. Have a good day.
Thank you.
Judge, just above.
Ms. Butterworth, before you leave,
Yes,
let me
ma'am.
ask really quickly. I was looking at the trial date. It's January 2024. I want to have that specially set because your client may still be in custody. And I want to make sure we have that placeholder for that spot. Any reason that we're not good with doing that? I intend to go forward on that date unless you all are asking for a different date.
I believe I've got those issues that I came and spoke to you about.
Oh, correct. Got it.
But they're so up in the air. So I believe that would work unless something were to come to my attention, like surgery, and then
That's
I
fine.
would of course notify the court and Ms. Ortega.
The reason I want to do that, so Myrna, on Mr. Bettis's trial on January 26th, We need to make that a special setting. And then, Mr. Marufo, we need to make sure we can secure maybe commissioners or ceremonial court to have a large panel. If things have to be moved, they have to be moved, Ms. Butterworth. But for now, at least I know you will be set with the appropriate accommodations.
And I will, on my part, I'll do everything I can to make sure that we're ready since my client is in custody.
Okay, thank you.
Thank you, Judge. May I be excused?
You may have a good day.
Thank you. You too.
Who's next?
Right above, the last one, Judge, on page 33. Annex, may we have Paderes? Robert Paderes.
It's coming up.
I did not bring back my summaries. I printed out all my case summaries and I don't have them. Okay, go ahead.
In cause number 2018-0D03894 and 2018-0D03078, State of Texas versus Robert Paderes. Announcement of council, please.
Compel or take it for the state. The state is ready.
Peter Escobar, and on behalf of Mr. Perez, and we are ready, Judge.
So I showed two different attorneys for Mr. Paredes. Is that correct?
No, ma'am, I'm representing him. I filed a motion to set bond a couple of weeks ago.
Okay, I show Santiago Hernandez on cause number 3894. Myrna, can you look at that, please?
May
I think
Judge?
he was Mr. Perez's attorney 2.5 years ago.
Okay,
May I, Judge?
yes?
I did contact Mr. Hernandez and he said that Mr. Paderes has not retained him. And he did represented him back in 2018.
Okay, so Mr. Escobar, did you file an entry on 3894?
I thought I had, Judge. I might have just filed the motion to set bond. I'll do that immediately.
Let me get to your case. Okay, yeah, I do see the motion, Mr. Escobar. If you'll just get us the entry, or if they can't, just change it.
Yes,
But
ma'am.
get us an entry on that case because of the docket, it'll be messy. Under us. Okay,
Yes, ma'am.
so we are set for a bond hearing in each of these cases. Mr. Escobar, you may proceed. Ms. Daly, are you on this case?
Yes, Your Honor, I am.
Okay, thank you. All righty, Mr. Escobar, you may proceed.
Yes, ma'am. Your Honor, my client is on deferred probation out of both cause numbers that's on your docket. It's my understanding that while on probation, he's finished all the classes, has always reported. The only thing he lacks, I believe, is $3,000 in probation fees, which he was actually ready to pay this month before he got picked up. And so he got picked up on a misdemeanor DWI. It's actually from January of 2022, Your Honor, and he was released at the time. So he really did not know that there was going to be criminal action arising out of that incident. And then in August of this year, the DA's office filed the complaint information that came out with a capias, and he was picked up. And that case is a misdemeanor pending in county court at law number 4, Your Honor. He's on a PR bond on that case, and he has the machine at home, the portable unit at home. And so I'm asking the court to consider a PR bond on these two cases. Again, he's always reported. I don't think there's been any problem in that area. After talking to Ms. Daly a couple of weeks ago, I don't believe that the department's recommendation is any type of revocation. My client, if released on a PR bond, will live at 3548 East Glen with his mother and brother. Your Honor, my client has just had twins. He had 6-month-old babies at home. His wife is unable to work because of the age of the children. He also pays child support to a 7-year-old. And so my understanding is that the situation is very dire at home for his family, and they need him out working. He was working for the last 3 or 4 years for a place called the Research Group, which does surveys online and on the telephone. And he also got a second job at the Golden Corral because of the birth of his children, Your Honor. He's not a flight risk, and I'm asking the court to allow him to released on a PR bond in these cases so he can defend himself on the DWI.
Okay, before I go to you, Ms. Ortega, Ms. Daly, is that basic summary, but for the probation fees or the financial, so to speak, was he otherwise, and of course, aside from the January 2022 DWI, was he otherwise a very good probationer?
He had picked up another offense while he was on probation, but he was convicted in a misdemeanor case. Other than that, he's reported as instructed. He's complied with his treatment, family violence counseling. He's complied with his community service.
What was the other case?
It was a violation of bond or protective order.
Okay,
Yeah, that's
And
going to
he
be the
was
case that Mr.
convicted of
Hernandez was part of, Judge.
I'm sorry?
That was good. That was the case that Mr. Hernandez was a part of a couple of years ago.
Okay. All right, anything else, Ms. Daly?
No, Your Honor. He's otherwise complied. His term is set to expire September the 19th of 2023. There's, as far as I understand, there's no motion filed.
Okay, I got you. All right, Ms. Ortega?
Yes, Your Honor, the state will be filing those motions and it's already been sent to be filed, so it should be by end of day. The victim in all of the family violence cases is the same, Alejandra Calleros. And because he can't comply with, without picking up any new charges, the state's gonna, be recommending time for this defendant.
The recommendation from probation is an admonishment on the new DWI, complete testing every 2 days. Are they still together?
No, ma'am.
Have we ever had any issues, Ms. Daly, while he's been on probation with, issues with the complainant, meaning has there ever been, complaints that he's harassing her or anything like that?
Well, that was the case that was reduced to a lesser charge, but he was allowed to continue on supervision. Since that incident, he has complied with reporting. He's complied with all of the other requirements, with the exception of the financial requirements. I did speak to the victim of this case, and she had mentioned that since that time period, she had not received any complaints or contact or anything harassing.
And I'm sorry, let me go back up. Is he on deferred? I'm sorry.
Yes,
He's
ma'am.
deferred, Your Honor, for 2 cases.
And primarily the basis for the bench warrant was the DWI, right?
That's correct, Your Honor.
Ms. Ortega, I'm not inclined to go there on the revo here. What's the status of the DWI? Are you
It's-
representing him on that, Mr. Escobar?
Yes, ma'am, I am. He hasn't even been arraigned on that, Judge.
Right, I'm showing it set for arraignment, and it's to be handled along with these motion to adjudicates that should be filed end of day.
Well, I'm going to grant your request for PR bonds in each of these 2 cases to comply with his conditions of probation. Okay,
Thank you, Judge. May be excused.
you may. Thank you.
That's all I have. Thank you.
All right, who's next?
Thank you, Your Honor.
Oh, thank you, Ms. Daly.
Second on page 32, Judge.
Your Honor, and I'm sorry, on the ag assault with deadly weapon, it's just a PR bond?
Yes.
Okay.
Go
I
ahead.
apologize, Judge. Last one on page 32, Judge. Annex, may we have Hernandez, Marcus, Ryan Hernandez?
Coming up.
Afternoon, Judge.
Good afternoon. Mr. Lopez, are you in a place so we can do this plea?
Yes, Your Honor.
Okay, let's get going.
In cause number 2022-0D04726 and 2023-0D01446, State of Texas versus Marcus Ryan Hernandez. Announcement of council, please.
David Vandenberg on behalf of the state. The state is ready.
Enrique Lopez on behalf of Mr. Marcus Hernandez. We're ready, Your Honor.
And David Nunez on behalf of Mr. Hernandez on the cause number ending in 1446.
And thank you. And Mr. Hernandez is appearing remotely from the jail annex. We are scheduled in each of these cases for pleas. Mr. Hernandez, is that what you're understanding you're doing here today?
Yes, ma'am.
Okay, can I ask you to speak up just a little bit? Maybe speak a little louder, please. In order to get started with your plea, I need to swear you in. Would you raise your right hand? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down, please, and state your name and date of birth for the record.
My name is Marcus Hernandez. My date of birth is July 13, 2001.
Mr. Hernandez, I have documents I received from each of your attorneys for both of these cases indicating your intent to plead guilty. Of those documents, the first one is marked as State's Exhibit number 1. Those are the plea papers for each case. Within that document or those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Hernandez, do you recall reviewing each of those plea papers with your respective attorneys and signing those documents?
Yes, ma'am.
Did you understand everything contained within those documents?
Yes, ma'am.
Defense counsel, have each of you had 10 days to prepare defenses in these cases?
Yes, Your Honor.
Enrique Lopez. Yes, Your Honor.
And did each of you explain the plea papers to your client?
Yes, Your Honor.
Yes, Your Honor.
Okay. Do each of you believe that he understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today, Mr. Nunez?
Yes, Your Honor.
Mr. Lopez?
Yes, Your Honor.
Mr. Hernandez, are you satisfied with each of your attorney's representation of you?
Yes, ma'am.
And either of counsel have any reason to believe their client is not competent to proceed with his pleas today?
I have no reason to believe that, Your Honor.
No reason, Judge.
Mr. Hernandez, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you today, I'm going to find that you are competent to enter your pleas. So are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Here in El Paso, ma'am.
El Paso, Texas?
Paso, Texas.
I'm sorry, it's hard to hear you, Mr. Hernandez.
Yes, ma'am.
Okay. In cause number 2022-0D04726, you are charged with 3 counts in that case. The first one is aggravated robbery. What is your plea? Guilty or not guilty?
Guilty.
Count 2, burglary of habitation with the intention to commit another felony. What is your plea? Guilty or not guilty?
Guilty, ma'am.
And count 3, injury to a child, elderly, or disabled with the intent to cause bodily injury. What is your plea?
Guilty.
In cause number 2023-0D01446, the charge there is possession of a controlled substance in penalty group 2 in an amount between 4 and 400 grams. What is your plea?
Guilty.
Are you making all of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor. Had these matters gone through trial, the state of Texas would have been able to prove beyond a reasonable doubt. And this is in 4726. That on or about the 20th day of October 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Marcus Ryan Hernandez, hereinafter referred to as defendant, did then and there, while in the course of committing theft of property and with intent to obtain or maintain control of the property, intentionally and knowingly threatened or placed Jesse Chavez in fear of imminent bodily injury or death, and the defendant used or exhibited a deadly weapon, namely a firearm. And is further presented that a deadly weapon, namely a firearm, was used or exhibited during the commission of the charged offense, and that the defendant used and exhibited the deadly weapon. Further, Mr. Hernandez, I'm having some problems with the there it goes. Mr. Hernandez also did then and there intentionally or knowingly enter a habitation without the effective consent of Martha Maldonado Ayala, the owner thereof, and attempted to commit or committed the felony offense of aggravated assault with a deadly weapon, and is further presented that a deadly weapon, namely a firearm, was used or exhibited during the commission of the charged offense, and that the defendant used and exhibited the deadly weapon. In the following count, 3, Mr. Hernandez did then and there intentionally and knowingly cause bodily injury to Martha Maldonado Ayala, an individual 65 years of age or older, by pushing or shoving Martha Maldonado about the body with the hand of the defendant. Mr. Hernandez did then and there also intentionally and knowingly cause bodily injury to Martha Maldonado Ayala, an individual 65 years of age or older, by pushing or shoving Martha Maldonado about the body with the hand of the defendant, causing her to strike the ground. In the second cause, ending in 1446, the state would have been able to prove beyond a reasonable doubt that on or about the 20th day of April, 2022, and anterior to present of this indictment, Mr. Hernandez did then and there intentionally or knowingly possess a controlled substance, namely tetrahydrocannabinol, in an amount of 4 grams or more, but less than 400 grams. At this time, the state would request that exhibits 1 and 2 be admitted to evidence, and exhibit 2 is the 1495 disclosure list, Your Honor.
No objection for cause number ending in 1446, Your Honor.
No objection on the other matter, Your Honor.
Okay, so states 1 and 2, 2 being the 3914 disclosures, are admitted without objection. What is the plea agreement?
In 4726, the state would recommend the defendant be sentenced to 10 years community supervision under the deferred adjudication provisions of the Texas Code of Criminal Procedure. The defendant be assessed a fine in the amount of $4,000, with $4,000 probated, payable immediately or in equal monthly installments throughout the term of community supervision in this cause. Additionally, the state recommends the imposition of all the standard terms of conditions of community supervision, as well as the following conditions. The defendant perform 400 hours of community service prorated monthly as a condition of community supervision. He be subject to TAP, UABAs, and a curfew, that there be no contact with the CWs or the place of the criminal incident. And in regards to the case ending in 1446, it's the same terms and conditions, except that the defendant would serve 5 years community supervision on the deferred adjudication provisions, Your Honor.
Okay, Miss Attorneys, is that your understanding of the plea agreement?
It is, Your Honor.
Yes, Your Honor.
And Mr. Hernandez, is that your understanding as well?
Yes, ma'am. Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled "The Trial Court Certification of Your Right to Appeal." It is a document that explains your appeal rights. Because these are plea, bargained, or negotiated cases, you do not have an automatic right of appeal. Mr. Hernandez, do you recall reviewing the trial court certification with your attorneys and signing those documents?
Yes, ma'am.
They were signed by your attorneys as well as the court. I do need to confirm, I failed to ask this at the beginning of your pleas on both of these cases. Mr. Hernandez, I did also in the paperwork receive your written consent form to conduct these pleas via Zoom. In other words, not do them in person. Is that your understanding and your agreement?
Yes, ma'am.
Okay, I just wanted to make sure. Okay, let's go back. Finally, motions for deferred adjudication. Mr. Hernandez, did you review with your attorneys in each case the motions for deferred adjudication?
Yes, Your Honor.
Mr. Lopez, explain to your client both the benefits and detriments of deferred adjudication.
I did, Your Honor.
Mr. Nunez,
Yes, Your Honor.
Mr. Hernandez, do you understand that if you violate any of the conditions of your deferred adjudication probation, the court can proceed to sentence you up to the full range of punishment for these offenses? Do you understand that?
Yes, Your Honor.
Okay, in cause number 4726, there are 2 first-degree felonies, a range of punishment 5 to 99 or life and up to a $10,000 fine. Count 3 is a third-degree felony, anywhere from 2 to 10 years. Do you understand?
Yes, Your Honor.
In cause number 1446, the range of punishment there is anywhere from 2 to 20 years and up to a $10,000 fine. Do you understand that range of punishment?
Yes, Your Honor.
Understanding all of that, do you still, are you still asking for deferred adjudication probation?
Yes, Your Honor.
Okay, I will find in each of these cases, there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement in cause number 4726. That will be for a period of 10 years. There will be, well, and in cause number, let me go to the other one, ending 1446, your probationary period is for 5 years. The conditions that will run concurrent with one another is a $4,000 fine, all of which is probated, 400 hours of community service, screen for TAP. You will have a curfew from 10 p.m. to 6 a.m. unless you are working or going to school, subject to urine and breath analysis, no contact with any of the complainants or the locations where these incidents occurred. As to counts 1 and 2 in cause number 4726, the court will make a deadly weapon finding. Again, these cases will run concurrent with one another. Is there anything further, Mr. Vandenberg?
No, Your Honor.
Mr. Lopez,
No, Your Honor.
Mr. Nunez.
No, Your Honor. Thank you.
Thank you very much. We are adjourned. Thank you, Mr. Hernandez.
Thank you, Your Honor.
Who's next? You all are excused. Thank you.
Same on
Thank you,
page
Judge.
32, Judge.
Mhm.
Annex, may we have Harris, Liliana Harris?
Yes, Your Honor.
Ms. Harris, is that you?
Yes, ma'am.
Okay, we're about to get started with your plea. For some reason, it's kind of hard to hear from over there, so just speak loud enough, right? Don't let your volume go down because it'll be hard to hear you, all right?
Okay.
All righty, let's get started.
In cause number 2022 0D04389, State of Texas versus Liliana Harris. Announcement of council, please.
David Vandenberg on behalf of the state, and the state is ready.
Mr. Dakotes, are you there? If you are, I need you to unmute and turn on your camera.
Thank you, Judge. Carl Dakotes on behalf of Ms. Harris, ready, Your Honor.
Okay, we are scheduled, Ms. Harris, for a plea today. Is that your understanding of what we're doing? Ms. Harris?
Yes, ma'am.
Okay, in order to get started with your plea, I need to swear you in. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Please state your name and date of birth for the record.
Liliana Harris, 0806-2003.
Ms. Harris, I did receive paperwork from your attorney, documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers for this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Harris, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Ms. Harris, I also received a document indicating that you consented and agreed to do this plea over Zoom, in other words, on the computer, rather than in person. Is that correct?
Yes, ma'am.
Okay. Mr. Dakotes, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
My office did. Yes, Your Honor.
Do you believe she has understood the admonishments, rights, and consequences of giving up these rights by entering her plea today?
I do believe so, Your Honor.
Ms. Harris, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Mr. Dakotes, any reason to believe your client is not presently competent to enter a plea?
No, Judge.
Ms. Harris, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Ma'am, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso, Texas.
Ma'am, in this case, you were charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 2 in an amount between 1 and 4 grams. The range of punishment there is anywhere from 2 years to 10 years confinement and up to a $10,000 fine. To that charge, ma'am, what is your plea, guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I'll find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Had this matter gone to trial, Your Honor, the state of Texas would have been able to prove beyond a reasonable doubt that on or about the 20th day of September 2021, in anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Liliana Harris, hereinafter referred to as defendant, to then and there intentionally or knowingly possess a controlled substance, namely tetrahydrocannabinol, in an amount of 1 gram or more, but less than 4 grams. At this point, Your Honor, the state would request that exhibits 1 and 2 be admitted into evidence.
No objection, Your Honor.
Dates 1 and 2 are admitted to be in the 3914 disclosures. What is the plea agreement?
The state would recommend the defendant be sentenced to 6 years community supervision under the deferred adjudication provisions. The defendant be possessed of fine in the amount of $2,000 with $2,000 probated, payable immediately, or in equal monthly installments throughout the term of community supervision in this cause. Additionally, the state recommends imposition of all the standard terms and conditions of community supervision, as well as the following conditions. The defendant performed 250 hours of community service, prorated monthly as a condition of community supervision, be screened for TAP, be subject to UAs and BAs, and a curfew, Your Honor.
Mr. DeCotes, is that your understanding of the plea agreement?
That's my understanding, Judge. Thank you.
Ms. Harris, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Ms. Harris, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Ms. Harris, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, ma'am, I do.
Mr. DeCotes, did you advise your client about the benefits and detriments of deferred adjudication?
Yes, Judge.
Ms. Harris, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment in this case? Do you understand that?
Yes, ma'am.
And are you still asking the court to grant you deferred adjudication?
Yes, ma'am.
In this case, I will find there is sufficient evidence to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication probation pursuant to the plea agreement for a period of 6 years. There will be a $2,000 fine that's completely probated, which means as long as you're doing what you need to do on probation, in other words, you're compliant, you won't owe the fine. If you fall out of compliance, you will owe the entire fine. 250 hours of community service, screen for TAP, urine and breath analysis, and curfew from 10 p.m. to 6 a.m. unless you are working or going to school. Is there anything further, Mr. Vandenberg?
Nothing further from the state.
Mr. DeCotes?
No, Your
Thank you
Honor.
very much. Ms. Harris, good luck to you, ma'am. Thank you. Who's
Thank you,
next?
Judge. Thank you.
Yes, you may. Bye-bye.
Second on page 33, Judge. Annex, may we have Maldonado, Jose Maldonado?
Ooh, here comes the rain. Hi, Mr. Munoz. You're muted.
Oh, boy, I was doing such a good speech.
I can only imagine, Judge. I can only imagine. You're muted again. What happened? Mr. Munoz, you're muted still. I'm missing all the good stuff.
Okay, can you hear me now?
Yes.
Okay, on this case, I am not ready to plea my client, and the reason why we set it for a plea out of optimism, hoping that the case on the aggravated assault with a deadly weapon, mainly an arson, would have been indicted by this time. It has not been indicted.
All right, let me get on the record real quick. Calling cause number 2023-0D02517, State of Texas versus Jose Maldonado. May I have announcements, please?
Mr. Ortega for the state. The state is ready.
Max Daniel Munoz and for the defense, and we are ready, Your Honor. And on
Miss-
this one,
Mhm.
I'm sorry.
Mr. Maldonado is appearing remotely. We were set for a plea. However, I understand there's an outstanding case pending indictment. Ms. Ortega, can you enlighten us?
Yes, it looks like it was in our office, or it is in our office. So Your Honor, it is still in process.
Okay,
Your Honor, the last time we spoke about this case was on July the 11th. And by this time, that's how come we felt optimistic enough that this case would have been indicted. This
yeah,
case has been around, that was since the 28th day of March of 2023. That's the case we were going to proceed on. And the new case, which is arson, was assigned and he was arrested and while he was still in jail at a charge on the 18th day of May of 23. So I cannot proceed based on this because
And just for purposes of the record, the case has been accepted as an arson, and he does have a pen packet.
he does. We had discussed this, not with you, but with other people.
so Judge, here's what are you gonna ask for? I understand you don't want to proceed today, but I think in anticipation of the plea, the remaining settings looks like they were canceled because I don't have anything beyond your 2801 hearings in this plea.
No,
So
Your-
in
they were-
custody,
They
and I
were
don't know
canceled.
anything about an arson.
Yes. That's a case that has not been indicted. The arson.
It was just accepted today.
Okay. I'm gonna reset, let me see, I'm not gonna reset. Escape, but when the arson comes around though, I mean, it's gonna need to be worked up, right?
That's
Judge?
correct, Judge. And by this time, back in July, we had discussed this, that we were going to work it up. And then by that time, we were going to plea all cases together.
Okay,
Unfortunately, it didn't happen.
so I don't want to push this too far down the road. I'm gonna reset your plea for 30 days.
Thank you, Your Honor.
And I would do it sooner, but I know September is not good. So I'm gonna do 30 days to give the state a little more time. Hopefully they can get it indicted if it's gonna be indicted quickly. So that you have an opportunity to at least give it a cursory look. And if we're not at a wrap up, we can get you scheduled quickly because of your client's situation being in custody.
Thank you, Your Honor.
All right, 30 days, Mr. Maldonado. We're still waiting on your arson case, okay?
Ma'am.
All right, thank you. All right, reset 30 days. Thank you, Judge. Take care.
Thank you. You too.
Okay, who's next?
The one just below it, Judge. Annex, we have Nasim, medium Nasim.
Yes. 454. 62, 57.
Ms. Bayan, you're there? Okay, all right, thank you, Ms. Nasim. We can get started.
In cause number 2023-0D02390, State of Texas versus Vivian Maria Nasim. Announcement of council, please.
Mr. Ortega for the state. The state is ready.
Ada's plan on behalf of Mrs. Nasim, and we are ready.
And for purposes of the record, Ms. Nasim is appearing remotely. We are scheduled for a plea. Ms. Nasim, Ms. Bayan, you all were in agreement to conduct this plea over Zoom, is that correct?
Yes, Your Honor.
Perfect. Let's get started. Ms. Nasim, I need to swear you in. If you would raise your right hand, please. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I do.
Thank you. You can put your hand down, state your name and date of birth for the record.
My name is Viviana Maria Nasim. My date of birth is 9/3/1964.
Okay, ma'am, I did receive documents from your attorney. The first of which is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Nasim, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, I do, Your Honor.
Did you understand everything contained within that document?
Yes, I did, Your Honor.
Ms. Bayan, have you had more than 10 days to prepare a defense in this case?
Yes, I have.
And did you explain the plea papers to your client?
Yes, I did, Your Honor.
Do you believe she's understood the admonishments, rights, and consequences of giving up these rights by entering her plea today?
Yes, I do.
Ms. Nasim, are you satisfied with your attorney's representation of you?
Yes, I am, Your Honor.
Ms. Bayan, any reason to believe your client is not presently competent to enter her plea?
No, Your Honor.
Ms. Nasim, have you ever been found mentally incompetent by any court?
No, I have not.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes, I have.
Okay, is there anything that has been, I don't need you to tell me specific diagnoses, but is there anything that has been diagnosed or any other thing that you are feeling, whether it's been diagnosed or not, that is preventing you from understanding what we're doing today?
No, Your Honor.
Have you been able to effectively communicate with your attorney throughout the whole case pendency, including today's plea?
Yes, I have.
Beautiful. So then based on my observations, your attorney's representations, I am going to find that you are competent to enter your plea today. Ma'am, are you a U.S. citizen?
Yes, I am, Your Honor.
Where were you born?
El Paso, Texas.
In this case, you were charged with the offense of criminal mischief in an amount between $2,500 and $30,000. Ma'am, to that charge, what is your plea? Guilty or not guilty?
I plead guilty.
Are you making your plea freely and voluntarily?
Yes, I am, Your Honor.
I will find you are making your plea freely and voluntarily. Ms. Ortega, would you summarize the evidence, please?
Yes, Your Honor. Had the state proceeded to trial in cause number 2023-0D02390, the state would have proven beyond a reasonable doubt that the defendant Viviana Marie Nasim, also known as Viviana Maria Nasim, did then and there intentionally or knowingly damage or destroy tangible property, to wit, a Toyota motor vehicle, by striking said motor vehicle with rocks thrown by the defendant without the effective consent of Raul Rios, the owner, and did thereby cause a pecuniary loss in the amount of $2,500 or more, but less than $30,000. And at this time, the state would move to admit State's Exhibits 1 through 3, being the plea papers, appeal waiver, and the 3914.
Any objection?
No objection, Your Honor.
States 1 through 3 are admitted. What is the plea agreement?
It's recommending 1244B2 deferred with additional terms, including $2,500 in restitution, which has been signed for by our office today, the mental health caseload, $1,000 fine, 100 hours of community service, UABA, no contact with Raul Rios, no contact with the residents at 9912 Trinidad, El Paso, Texas, 79925, and no contacts with the residents at the above listed address.
Okay, Ms. Bayan, is that your understanding of the plea agreement?
Yes, Your Honor, and I just want to clarify that clearly we are pleading to the lesser included offense, and as the plea paper state in the judicial confession, it has the language unless I am pleading to lesser included. So we're pleading to the lesser included amount of the Class A.
Correct. I had this down as 1244B, so that would be a Class A criminal mischief in that amount.
Yes, ma'am.
Okay, Ms. Nasim, is that your understanding of the plea agreement as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Ms. Nasim, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, I do, Your Honor.
It was signed by your attorney and signed by the court as well. Finally, the motion for deferred adjudication. Ms. Nasim, did you review that with your attorney before you signed it?
Yes, I did, Your Honor.
Ms. Bayan, did you explain to your client both the benefits and detriments of deferred adjudication?
Yes, I did.
Ms. Nasim, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment? In this case, it would be up to a year confinement. Do you understand that?
I do, Your Honor.
Okay, and are you still asking the court to grant you deferred adjudication?
Yes.
Okay, the court will find that there is sufficient evidence to substantiate a finding of guilt. However, I will not enter a finding of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement and in accordance with 1244B of the Texas Penal Code for a period of 2 years. There will be a $1,000 fine. The entirety of that is probated. 100 hours of community service subject to urine and breath analysis, no contact with the complainant or the residents or the residents of that residence. And there is a restitution amount of $2,500 payable to the complainant. Is there anything further, Ms. Ortega?
No, Your Honor, thank you.
Ms. Payan?
Yes, Your Honor, I would just like the court to know that Ms. Nasim and her daughter in a good faith effort, we have already paid that restitution. I submitted a cashier's check in the amount of $2,500 payable to the complaining witness this morning to the state. Additionally, with regard to Ms. Nasim, she is to be on the mental health caseload.
Hold on a second. Who are we hearing? Is it the jail? Yes? Okay, go ahead, Ms. Payan, sorry.
That's okay. I've emailed probation. I briefly spoke with Ms. Pineda earlier today, at the courthouse. We would ask that Ms. Nasim be allowed to go to her own treatment provider, Dr. Vanderpool with Atlantis. I suppose that becomes, if there are any issues, we will continue to work with her to be sure that we can get her linked to where she needs to be.
Okay, that's fine. Anything else?
Not from the state, Your Honor.
Nothing further. Thank you, Judge.
Thank you. Good luck to you, Ms. Nasim.
Thank
Wish
you.
well. Thank
Yes,
you.
Your Honor.
Thank you, Ms. Payan.
Thank
Who's
you. I have a
next?
question I have a question for Mr. Ortega. Who's the TA handling the misdemeanor? I want to try to get that put through, if not tonight, tomorrow.
I think I copied him on the email, Ms. Payan, but I can find it again after I
That's
get out.
fine. I'll look. I just don't have my phone with me. I'll look.
Yes, and I'll make sure to copy you on any correspondence. I typically do that after these hearings, but we've just been in docket all day.
Right, because that's gonna hold up her release, so I want to make sure we get that. through.
Understand? Yes,
Okay,
I will work
thank
on
you.
it right away. Thank you, ma'am.
Thanks.
Thank you.
Thank you. Who's next?
Page 34, Judge. Annex, may we have Taylor, Frederick?
Okay.
Oh, Mr. Taylor.
Does my microphone sound better?
It sounds great, Mr. Huffman.
Does it really?
I don't know. It's like a little muffled, but I can hear you.
Okay.
Deborah Lee will tell you if it's a problem.
My assistant was messing with it, so I was hopeful.
Taylor. Okay, let's get started.
In cause number 2021-0D02596 and 2023-0D04939, State of Texas versus Frederick Elvis Taylor. Announcement of council, please.
I'll take it for the state. The state is ready.
Rick Huffman on behalf of Mr. Taylor, we're ready.
David Bruce, adult probation.
And Mr. Taylor is appearing from the jail annex. We are set for bond hearings. Mr. Huffman, go ahead.
Thank you, Judge. Mr. Taylor is a 22-year-old United States citizen. He's been in the El Paso for 5 or 6 years. He currently lives with his mother, her husband, and Mr. Taylor's 2-year-old son. Yes, son. The 2-year-old son, his mother does not have custody and basically has lost custody. So Mr. Taylor is helping basically his mother watch the 2-year-old son. He's been on probation, Judge, since April of last year. And as far as I know, he's been doing okay. The affidavit, the recent affidavit at least, shows the new allegation, the new aggravated assault, and nothing else. So it seems, at least based on that he's doing okay on probation. Judge, he hasn't been able to do the community service because he's been, and I don't know if the court's aware, Mr. Taylor was robbed and shot in the foot. He had 3 surgeries while he was out. This was about 6 months ago when this incident happened. the foot's not getting any better, Judge, especially while being in custody. I don't know how it looks now, but last time I talked to Mr. Taylor, it was purple. And he's losing feeling in his toes. I don't think he's getting the proper medical care in the jail. And we certainly have some concerns about Mr. Taylor losing his foot. I talked to his mother, Tamika Taylor, earlier today, and she said that, and I don't know if it's true, but that the jail was talking about maybe Mr. Taylor losing some toes. So I'd certainly like him out to get some treatment on that foot. He was in a boot on the outside, and he was getting physical therapy. It seems like that injury has regressed. And Judge, and it's caused a number of issues. He's fallen in the shower at the jail. I think Mr. Taylor believes that he has re-broken his foot, that he hurt his thumb and his wrist in that fall. So we have some urgent and serious concerns about Mr. Taylor's treatment. He hasn't been able to work, Judge, since the injury. Before that, he was working as a construction worker, delivery man, a number of jobs and trades. Your Honor, he denies these allegations, the current allegations, without getting too much into the facts, Judge. It's my understanding that he was simply trying to break up a fight. Mr. Taylor is being held on 2 counts of aggravated assault. Those are the new charges. They're each at a bond of $75,000 each. So a total of $150,000 for the 2 counts. He's on a no bond for the probation case. He's been in jail for about 33 days. Your Honor, I've spoken to his mother, and his mother has very limited money, but she believes through family and friends that he would be able to raise a bond premium of about $1,000. So we would ask the court to consider reducing the bond to something that is reasonable and that's something Mr. Taylor could afford.
So are you telling me the prior injury? I know we were here on a bond hearing because there was this, amongst other things, I think Mr. Bruce was present for that, this mysterious shot foot. And there was no real understanding of what happened. And now you're telling me he was the victim of a robbery. Is that right?
That's my understanding, Judge.
Okay. Anything else?
And it was actually, I think I could get into that a little bit.
No, that's okay. It's just that I remember that hearing and it was just like this big mystery. What happened to his foot? How he got shot in the foot? There were no details about a robbery. He was there present. He didn't say anything. Let me ask you this. You said he lives with mom and dad. The alleged incident where the new case, did that happen at his mom and dad's house?
I think it happened at, no, Judge, it's my understanding that it occurred at a business, but I don't know the specific address. I do not believe it happened at mom's address. The address mom gave me is 4554 Hercules, apartment 8.
Let me go to Ms. Ortega. Ms. Ortega, go ahead.
Yes, Your Honor, there is a business nearby. It's right next to these apartments. That's my understanding. So the facts are important here, so I'm just going to briefly get into them. So the victim arrives to the address, both victims, they're going to pick up his cousin and they're, maybe getting into a verbal argument. But the defendant then comes over and threatens them with a gun and says, that their loud talking is, as Mr. Huffman put it, or, arguing, is ruining his business. What business that would be, the state does not know, but we, at some point it escalates and he does fire a round. That spent casing was located at the scene. He did threaten them and said, quote, "You better leave before I blow up this B word." I do think it's important to note here that the defendant is a gangster disciple who had previously been on probation for hitting Devontae Harris, a different victim, with a weapon and causing him to bleed, and that there are two new now victims in this case that that the state is alleging that Mr. Taylor has threatened. So respectfully, we believe that the bond is set appropriately, and we ask the court to consider that he's a danger to the community and the evidence that the state is alleging to have found at the scene.
Anything else, Mr. Huffman?
No, Your Honor.
Okay, the motion on the new case is denied. As to the probation case, I'll set his bond at 100,000 cash surety. Thank you very much.
Thank you.
Thank you, Mr. Bruce. Who's next?
Thank you, Your Honor. May I be excused?
You may.
I believe
Thank
that's
you,
at
Your Honor.
the end of our docket, Judge.
That's the end of the docket?